A proud DC Bar member benefit, LawPay makes it easy to securely accept payments anytime from anywhere. Their proprietary technology prevents commingling of earned and unearned funds and protects your trust account against any third-party debiting, ensuring compliance with ABA and IOLTA guidelines. Schedule a demo at lawpay.com/DCBar and see why LawPay is trusted by 50,000 law firms. MyCase is a top-rated end-to-end legal case management software that helps firms run efficiently from anywhere, provide exceptional client experience, and easily track firm performance. Streamline day-to-day firm processes in one easy-to-adopt solution. Lead tracking, client intake, case management, e-signature, billing payments, and more. DC Bar members are eligible for a 10% lifetime discount. Start your free trial, no credit card required, today.
Hi, everyone. I'm Kirk Schroeder. I'm an attorney with the law firm of Schroeder Brooks Law Firm, and I'm an entertainment attorney. Been practicing for many years, and just want to welcome you to an edition of Brief Encounters, which is by the DC Bar. I am super excited today because I have with us today long time friends and colleagues. I can't even begin to think how long we go back and some of the laughs that we have. But in particular, they are just, I think, the premier experts in music licensing. And so this podcast and the next one that will follow, we'll be talking about music sync licenses. And today we're going to focus on film, music sync licenses for film, and then follow up on a music sync license podcast for television. So without any further ado and suspense, I'm pleased to say that Todd Brabeck and Jeff Brabeck, his brother, are with us today. Todd, former executive at ASCAP Publishing. Todd, just a brief background of what you did at ASCAP.
Oh, I was executive vice president for many decades and was head of all the membership operations as well as distribution, and really assigned many of the ASCAP writers and songwriters and composers, and also significantly changed a lot of the ASCAP distribution payment rules, which were in effect throughout my entire career.
And next to him is Jeff Brabeck, who is a business and legal affairs head at BMG Chrysalis. Jeff, do you just want to give quickly what you do right now with BMG?
Yeah, thanks, Kirk. Yeah, it's BMG Rights Management is the current name of the company, and our parent company is Bertelsmann in Germany. My role primarily these days is in acquisitions, which goes along with what's happening in the market today. Just buying companies, buying writer royalties, et cetera. I also get involved with music licensing issues when they become more complex than your normal situation, and also a new technology distribution.
And before I announce your book, Jeff, what are you doing right now with the new copyright law? Can you tell us what you're doing with the royalty scheme that is coming out of federal law?
Well, right now I'm a member. I'm the board of the MLC, the Mechanical Licensing Collective, and there are proceedings right now with the Copyright Royalty Board about what the mechanical rate is going to be, not only for the year starting in 2023, but for the past 5 years, which are under appeal by the digital companies. So we're heavily involved in those rate proceedings. They're very expensive. It's basically a trial, and so that's what's going on right now. So there's a dual thrust down in the Copyright Office with the copyright royalty judges, an appeal of the current and past rates, plus a determination of the future rates.
Okay, great. And then finally, I just want to give a quick plug for your book, which is Music, Money, and Success. I think it was like the 8th volume. Am I way behind? Is it 10th now?
No, it's the 8th edition.
Okay, 8th. Okay, I was right. We're going to have a link to the book. It's probably the most comprehensive. I'm going to just say, I think it is the most comprehensive book out there on any type of music licensing. And so for those of you that are interested in this area, just want that as a reference. We'll have a link to that with the podcast.
The book covers in detail chapters on film and TV and video game sync licensing and composer contracts and everything else. So it really goes into detail about everything we're going to be speaking about today.
Okay. We don't have a lot of time, so we're going to try to move as quickly as we can and be as comprehensive as we can. Let's just start with the basics. If you have a film, if you're an attorney listening to this or a filmmaker, and you want to use someone's music and actually synchronize that music, a part of it, with the film, you need a sync license. We're going to just start with the basics of I want to use, let's say, 30 seconds of a clip of a popular song for my independent film. Now, Jeff, I know you've got some stats of how sync licenses have been used with the Oscars. Do you want to go ahead and just give a perspective on that right now,
Yeah.
and then we'll talk about the process?
Yeah, good, great, Kirk. And I'll be very quick about this. I'll give you a few examples so people have a perspective as to what we're talking about. We looked at the Oscar-nominated films right now, and we licensed a number of songs, pre-existing compositions, into those motion pictures. I'll just give you a couple examples. Coda, we licensed Starman, which is a David Bowie song. Licorice Pizza, Life on Mars, also David Bowie. My Ding-a-Ling, which was performed by Chuck Berry. The House of Gucci, Heart of Glass, the Blondie composition, Raya and the Last Dragon, We Are Out Here, etc. So the list goes on, but basically what we're doing is licensing musical compositions that are existing. And the discussion that we're going to have today could also relate to master recordings as well, the actual performance of the song that's owned by the record company normally.
And that's an important distinction. So we're either synchronizing music that the producer will perform or hire out to be performed, or the actual use of master recordings. Right. Those are the two scenarios we're talking about. Okay, I've got a client and they want to license, let's say, a David Bowie song, let's say just 20 seconds, perfect part in a film. My client is not an Oscar winner, but does have some decent credits in filmmaking and on the film festival circuit. What do I do, and how likely can I even get someone to talk to me about these things? And when they do, let's just talk about the terms. So what's my first move?
Great, Steve. The first move, and it's normally via email or text, but it's primarily email. On occasion, there's a phone call, but it's usually an email. And basically what the lawyer who represents the composer should do is, first of all, you've got to identify the production company, identify the film, obviously. You give a synopsis of the film, first of all. So the company that is licensing the music at least initially knows the general nature of the film itself. Obviously, you give the identity of the composition. Many times, if like you mentioned indie film, you should really mention the budget. If we get a request from a Warner Brothers or Universal, et cetera, we know pretty much that it's a fairly large music budget in most cases. With the indie motion picture producers, you've got to give a sense as to what your budget is so that we know whether or not the license will be attainable.
Budget on how much we want to spend on the license?
It's always helpful, let's put it that way. What's most important is the synopsis and the actual scene description. Just what is exactly occurring in the scene where you're asking, to use the musical composition or the master recording. Especially for indie producers, that's essential because, most companies will look at indie films. There's not much money involved many times, but if the plot and the scene description is a very positive situation, and will be good for the song, the pairing of the song and the film, we'll look at it different. So the scene description is extremely important. Also with scene descriptions, why we ask is because in many of our agreements with our songwriters or composers, there are restrictions. There are, situations or types of scenes that they have permission over, that they have to give their permission and consent. And so the more specific you can be in a scene description, is better for us, because if we have a situation where we have to go to the composer or songwriter to get their permission, we can at least tell them what the scene is about. Now, a lot of these restrictions have to do with scenes of extreme violence, nudity, etc. So the scene description is extremely important in any request. Also, use of the composition. Is it going to be sung by a character in the film? Is it going to be sung by a band on the stage? Is it going to be a background vocal? Is it going to be a background instrumental that is, performed by the producers, orchestra, et cetera? So use of the composition is very important. Duration. Now, many times the filmmaker doesn't know what the exact duration is because you're editing the film. You've got a scene that might be 30 seconds. You've got a scene that might go further. You've got a scene that might go into another scene where the song still plays, et cetera. So, most times we get a request, it'll say up to a full duration, which will give the filmmaker, at least some leeway as to how he or she wants to use the song. But in many situations, when the scene is already shot, which it almost always is, unless there's an actor singing on camera, they know what it's going to be. Is it going to be a 30-second scene, 30 seconds or less, or it's going to be 45 seconds? So duration of the use is really important. Territory, virtually all films will want the universe or at least worldwide. There are some documentaries and some smaller films, and I'll get into film festival situations where you're looking at US only or limited territories with expansion of rights based on an option basis.
Yeah, but I would just say, yeah, as a lawyer representing the film, if you don't have worldwide or universal rights, it's almost malpractice unless there's like an experimental film or a student film or a film festival type film, because just means that when other territories are being negotiated, we've got to come back to you.
Yeah, so that's definite. That's why in some of these deals, if it goes that direction, there are guaranteed options, to expand the territory for an additional fee. But yeah, I agree with you. Any producer who only goes for a limited territory without any guaranteed options is crazy. So you're totally correct on that. The term, usually life of copyright. A lot of motion picture producers like the words in perpetuity, but that means nothing to me because you can only license a song while it's under copyright. So most of these uses are all life of copyright. So in effect, once you license the song or master into a motion picture, it can stay in that motion picture for the life of copyright of the composition. The rights being requested, this really depends on the producer. I mean, the motion picture license is normally referred to as a broad rights license. And, broad, it's as broad as you can get. It's basically any distribution channel which is in existence, from motion picture theaters to streaming to you name it, that's now in existence or may be developed in the future. That's very, very common as far as the rights being requested. For the producer, you definitely need those rights. And that's why the agreement is called a broad rights synchronization license. It also includes, home video, personal video, et cetera. So there are no back-end royalties, at least as far as the synchronization aspect of a motion picture license. And Todd will get into the back-end royalties for other areas. Basically, there's a one-time fee in most cases. The fee could be $5,000. It could be $25,000. It could be $750,000. This is a field where it's all bargaining power. There are no statutory rates that we're talking about. So it's really a combination of how badly the producer wants the song or the master recording and the music budget. And, if your song does not fit in with that budget, then, the producer will normally go and try to get another song. Then there are issues like, is it going to be used as an opening credit use or a closing credit use? Those uses cost more money in most cases. So that's another issue. And then the final thing, which you brought up, is it a major film? Is it an indie film? Is it a documentary? What are the budgets involved? How much money does the producer have? Those all come into play when you're licensing music. But once again, the scene description and the synopsis of the film is extremely important. And I can tell you right now, there are certain songs which are very hard to license. Most songs are not. For those that are not that hard to license, and even those that are hard to license, if the scene is good and the synopsis and what the film is about is really, really excellent, and the writer is sold on it, the songwriter, then you've got a very good chance, even with the indie films, of getting a synchronization license. Yeah, just two quick things that, in addition to what Jeff covered, if there's a thematic use, if you have multiple uses of the song that the producer wants to use within the film, you always charge more because it really carries the story along when you use the same composition multiple times in a film. Also, these licenses also cover in context promos and trailers. So, that's always an important element of it. Yeah, and unless you mentioned indie films, what we and other publishers do with indie films, there's something called a step deal license, because we are looking at a producer, who does not have that much money in most cases. And the normal licensing fees sometimes will not apply to them because the fees are just too large for a lot of these really smaller indie companies. That's why we might get involved with a step deal. And a step deal is simple as there's steps. The first step is a film festival license. So at least the producer can show his or her film at film festivals with the music that that producer really wants, in his or her film. The next step could be if, in fact, they get a streaming deal from the film festival. That's another fee. If they get an indie distribution for theatrical distribution in the United States, that could trigger another fee. If they get foreign distribution, if they sell the film to foreign territories.
But usually those steps and those terms are going to be laid out up front, right? I don't have to come back to you each step and renegotiate, do I?
No, you're totally correct. The worst thing in the world is to try to come back to a company and add additional terms. What you should do, as Kirk suggested, you put everything in that step deal. You make it very specific. And the whole purpose of a step deal is that if we as a music publisher are letting our song be licensed at a fee which is less than we would normally license it for, just because the project is good, if all these steps happen, the amount of money in the synchronization fee will equal what we would have charged had the film had major distribution. So that's the whole point. But you better put everything in that step deal and not leave anything out, with dollar amounts included.
And I think it's very important to have all of this organized up front, because really, when you talk about the allocation of time, your staff is probably not going to spend so much time on something that's smaller, less reliable as to whether it will get into the marketplace or not, versus the sure things which come out of the studios with much larger budgets.
Yeah, that's a really good point. And many times what the film producer should do is to try to contact the songwriter of the composition and get that songwriter involved. Because if the songwriter is backing the film, at least emotionally, the songwriter will come to us and say, hey, can you put this on the top of your pile or near the top? I would like to do this. I just want you to know that I think it's a good film. So many times it's that third party who's actually involved with the song or the master recording coming to the music publisher or record company saying, can you do this for me? Because it's a good project. And then, that's one way to get your use, push more to the top of the pile than all the way at the bottom, because, there's a lot of requests coming in, and somehow you're going to have to just distinguish your request from everything else that's coming in, especially to the big companies.
Okay. Hey, Todd, can we talk about back end? Is there back end in any of this, or what should the lawyer know going into dealing with the publisher about back end issues and royalty payment?
Yeah, well, one of the back end really is essential to have an understanding of it, because that's really part of every type of consideration, both for the music publisher as well as for the person who's making requests. For the music publisher, what they're looking at is that you've got an initial fee, which Jeff just discussed himself, a one-time fee in most cases, then with options. But that if it's a film or a documentary or an independent or major film and stuff like that, it's hopefully going to have a foreign theatrical release, a release in foreign countries. In foreign countries, there are organizations called performing rights organizations, PROs, ASCAP, BMI, CSAC, and GMR in the United States, SACEM in France, PRS in England, GAMA in Germany. These organizations license the users of music, collect the money, and then pay it back to writers and publishers. Now, when you go outside the US, anytime you have performances in a motion picture theater, it's called a theatrical box office release. And in all those countries, the PROs in each country license the music in the film. They collect it and they send it back to, in our case, US composers and music publishers. And it's normally about 1% of the box office as a general figure. So to just take an example of like the movie The Avengers, Endgame. It had $1.939 billion in foreign box office receipts. Now, just think about 1% of that money. There's a lot of deductions taken off the top, but there's a lot of money involved in that 1%. And that money went to Alan Silvestri, who did the score. But then you had songs by the Stones, you had Led Zeppelin in there, you had the Kinks, you had a Harry James 1945 composition. It's been a long, long time in that film. So there's an old song and contemporary songs all making money from this foreign theatrical release money. In the US, movie theaters are not licensed, so that's not a source of income. ASCAP, BMI, CSAC, and GMR, they license television, cable, and the audiovisual streaming services. So you can make significant amount of money for that. Let's say you have one song on a network. Let's say the movie is shown on network TV prime time. You have one song in there. It could be run between $1,250 to $2,500, right, or equal amount publisher.
But the publisher is going to dictate that to me, right,
Yeah.
as representing the indie. And
Yeah,
what's
and
usually that rate? There's just going to be a rate that's going to be dictated by the publisher to the licensee, or will that just be handled separately by the publisher through the PROs?
Yeah, no, what will happen is the PROs will license the users of music, let's say CBS network, HBO, Netflix, Amazon, whomever. They negotiate a deal, they collect the money, and then they distribute the money back to writers and publishers and composers based on their own royalty formulas, based on the amount of money that comes in license fees. So it can be a very complex area, but I'm simplifying it there, but that's how it works.
Well, but you also make a good point. This is a sidetrack. If you're representing a songwriter who has music that is synced to a film, you can't forget the back end royalties that may be paid from foreign box office.
Correct. Well, one last thing on the back, there are so many back end types of royalties, but here's one that nobody ever thinks about. You've got, take the Broadway theater. You have Moulin Rouge, which was a movie. We went into the Broadway. It's it's on Broadway currently, or at least will reopen again. It had 70 pre-existing compositions in there, and the royalties for Broadway are based on either the percentage of the box office that comes in, or a different formula, royalty pool formula, where you're looking at the amount of the box office for a week, and then you reduce it by the running cost of that particular show. All the rest of the money, a certain percent, is shared by all the songs within that show. So, and it can be add up to a significant amount of money. But there is an area, again, it's a back end royalty, but it's really for songs that were in films that then translates into Broadway. So again, look at Lion King, Rocky, Aladdin, any of those things apply.
Wow. Okay. Gosh, we could just keep talking about this all afternoon. So do's and don'ts for the lawyer representing the filmmaker. There is a practical side of this, of just being realistic and being organized and knowing what to ask for. And I think, Jeff, you've gone through that pretty well. And to be realistic, they're not going to spend so much time negotiating this with you. You're just going to get mainly the terms laid out, if you're lucky, and be happy that you've got those terms, right? For the most part, unless you're representing a very major producer of some sort, or director that's a film.
Yeah, but I must say, because the motion picture sync licenses is most of it is non-negotiable. They're very straightforward forms. They're about anywhere from 5 to 7 pages. So we're not talking about a long document. The first 5 pages might be all the boilerplate that you see normally, grant of rights, indemnity, et cetera. And then, the last page with some of the variations, that you agreed to, including the timing. So, but really, there's not much negotiation involved. The primary negotiation has to do with the fee, because all the rest of the items are fairly straightforward. Other than another thing, change of lyrics, very important aspect. That can either caused the publisher and the songwriter to say a definite no, regardless of the price, because a change of lyrics sometimes in the right scene or the wrong scene can stick with the composition, and that could hurt future uses of that composition, because a lot of people will remember that particular scene, especially with the change of lyrics that either make it comedic or give it a different context. That's also true of certain scenes with extreme violence, etc., that sometimes these scenes stick with songs, and that's very dangerous for the future earning power and licensability of a composition.
Jeff, let me ask a very practical question that sometimes comes up with me. Get a sync license, everybody's happy, the film gets distributed, and then it ends up in China or Russia, where there's no rule of law, and essentially you've got infringement. Is it up to me to try to enforce or do something about that infringement, despite the fact that my client has barely made enough money to pay the sync license bill? Or will the publisher take care of that? Or do you even care about those circumstances?
Well, we definitely care. I mean, our concern.
And I'm being facetious. I know you care.
Yeah, but our role is within the 4 corners of the agreement. We will, of course, try to assist motion picture companies because if their film is being infringed, our composition is being infringed also. I mean, we've given a sync license, but we've not given a license for further
I'm just saying, as a practical matter, it's not uncommon. There are these outfits out there that just pick off any type of film. From a place where there's no rule of law or the ability of the United States long arm to police anything. And I just didn't know if that was an issue that you see often, or it's just something to be aware of, or not even to concern yourself with it right now. Just kind of go with it, I guess.
Yeah, I mean, the way we look at it, it's primarily the motion picture producers, obligation, and then also the organization, MPAA or whatever the organization is their responsibility as opposed to ours. We'll assist, but it's really the obligation of the.
And so then it's important for the producer's lawyer to make sure that may fall on the distributor, who will actually be responsible for distributing or streaming to police that, rather than your client. All right, I don't want to get too bogged down. What other do's and don'ts are there as a practical, or any little legal catches that someone needs to be aware of in this area, especially in representing the filmmaker?
Really, it's just being very straightforward and requesting exactly what you need. Simple as that. I mean, there are exclusions which you're going to have to deal with, in a lot of these licenses, which you should be aware of. If we license a song to a film or to a particular scene, if you're a producer, you can't use that song in a trailer, over a number of scenes. You can use the scene itself in the trailer, but that's something which you've got to realize. You can't reuse it as part of a webisode or behind the scenes footage unless you get permission. Obviously, if there's an editor's cut, fine. If the scene is extended a little bit, that's acceptable. But there are areas which are outside the four corners of the motion picture, which are definitely excluded. The film has to be nonlinear. We can't get into a situation where the consumer, or the person watching the film, can change a particular scene. So, all of these licenses.
Use a lot of children's programming. You have to pick the scene for the end of the film. Got it.
Yeah. Yeah. If you're dealing with something like that, and that's happening, where, consumers or people watching television or motion pictures, TV primarily right now, can actually change the course of the TV series or the film, et cetera. So that's coming. So, but that has to be provided for in the license itself.
Okay. All right. One last question. Music clearance companies, am I better off telling the client to hire a music clearance company? Do they have like a special end or a special credit card that can get in the door? Or am I just effective if I'm competent in this area as an attorney?
It's all over the place. Most producers, well, if you don't have in-house staff, like some of the big companies, I would suggest a music clearance person. They know the ins and outs. They know who to talk to at a particular company. They know how to present something in a manner that the company that they're going to is used to. So it can never hurt. Let's put it that way. A lot of indie producers can't afford them, et cetera. But I think it's a good idea, because when something comes in professionally from someone or a company that we know, obviously we treat it a little bit different because we're used to the company, and it comes in the right format with all the questions answered, as opposed to us having to go back and email, 2, 3, 4 times, whatever, to get more information. So it's always wise.
Got it. All right. Just any closing thoughts, so do's and don'ts, or things that the audience should be aware of in this area that we either haven't covered or you want to emphasize?
No, I think it's important, though, for in any negotiation, for if you're on the producer side, the production side, that you are aware of what the back end royalty scenario is for the music publisher and the songwriter and composer, because that'll always be helpful in any negotiation as to the price.
Jeff, I'm going to give you the final word, please.
Yeah, one last thought. It's very important for the producer to have someone who's very qualified do the music cue sheet. That is essential for the payment of royalties, for all these back-end royalties. And that's one thing that's part of the license. And it should be done very, very correctly. It has to be very specific as to whether a song was used as a visual vocal, the timing, what the composer's name is, the Performance Rights Society, et cetera. We've got a lot of information in the book on that. And also, just so the audience knows, our film chapter in the book starts off with 2 conversations, actual conversations, so you can see how these conversations work when someone's licensing a song. But cue sheets are important and they need to be done correctly.
Great. And the book again is Music, Money, and Success, the 8th edition by Jeff and Todd Braybeck. That's been a whirlwind already in this podcast on music sync licenses for film. I'm Kirk Schroeder with the law firm of Schroeder Brooks. And I want to just give a big shout out and thanks to my friends, Todd and Jeff Braybeck. Just a teaser, we are going to come back and do another podcast on television sync licensing. And so that's going to come out probably, we'll get that done in the next several months. So be on the lookout for that. So on behalf of the DC Bar and Brief Encounters, Todd and Jeff, thanks.
Hey, all the best, Kirk and the DC Bar. We wish you all guys all the best.
Yeah, it was a pleasure. Thank you.
This episode of Brief Encounters was brought to you in part by our sponsors LawPay and MyCase. Find out how these solutions can work for you by visiting lawpay.com and mycase.com. For more information, check out the description of this episode.